Good morning, students. We are meeting after 2 days. How are you? How are you feeling being at home? I know you must be feeling bored, but what to do? We have no alternative. And we cannot do anything, but we can help the government by being at home, confined within the four walls of the house, helping our parents and doing some household chores also. And I hope you are all fine. I had a little throat problem, but by now I am okay. I had pharyngitis, and now I am feeling much better, and I I always feel excited to be with you for some time at least. But it would have been a pleasure if I could have contacted you through Zoom classes, but I find it little difficult to contact through Zoom. Anyway, somehow we have been able to contact ourselves in the Google Classroom, and hope you are enjoying all the classes of all the teachers. And that day I gave you a note in the WhatsApp, and perhaps you have copied that note. I'm sure you have copied those notes rather, on public interest litigation. And today I again plan to discuss the concept of public interest litigation, concept, meaning. And I know that it is almost clear to you, but repetition definitely will make you clearer, will be more understanding towards public interest, towards understanding the concept of public interest litigation. And I told you, as a matter of fact, that public interest is a matter of public or general interest in which a group of the community or a class of the community have a pecuniary interest by which their legal rights or liabilities are affected. Do you know what is pecuniary interest? Pecuniary interest related to money. Pecuniary interest means interest relating to money. So, public interest litigation is primarily concerned with with the pecuniary interests of a community where it has been affected, which has affected their a class of the community's legal rights or liabilities. There is a dictionary by Black, and in the sixth edition of the dictionary, the writer is Black. It is said that it is something in which public interest litigation is something in which the public, the community at large, has some pecuniary interest or some interest by which other legal rights are affected. The same thing as I discussed before, when the legal rights are affected by some pecuniary interest of a group of public or a part of the community or the community at large, then the question of public litigation comes into being. And interests, not all the interests are public interests. Keep it in your mind that not all the interests are public interests. Interests shared by citizens generally in affairs of local, state, or national government are the public interests. You have got the concept of interest shared by citizens generally in affairs of local, state or national government or the public interest. Now, what is litigation? As the term connotes, this expression means a legal action, including all judicial proceedings therein, initiated in a court of law, and the purpose of initiation is to enforce a right or seeking a remedy for restoring some rights that have been affected. Therefore, the expression PIL means legal action initiated in a court of law for the enforcement of public interest or general interest, by which their legal rights or liabilities are affected. So by now you are clear the concept of public interest and also what the word litigation means. In India, the seeds of the concept of PIL were initially shown by Justice Krishna Iyer in 1976. However, that time he did not assign the term public interest litigation. Later on, in the year 1981, that day I forgot the year, I have spoken perhaps 1986. It is not in 1986, it is 1981. Justice Krishna Iyer said, and he used the terminology public interest litigation, and also used the expression epistolary jurisdiction. Epistolary jurisdiction in a case named Fertilizer Corporation Kamgar Union versus Union of India. So I have given you already in the note, but we are repeating so that you can remember correctly. So when you read, everything comes into your mind, and your mind restores everything in your memory box or in your memory card. In the year 1986, R.B. Mishra of the Supreme Court observed that public interest litigation is a comparatively recent concept of litigation. It is a recent concept of litigation, but it occupies an important status in the new regime of public law in different legal systems. After discussing all these things, we will also discuss the drawbacks or the difficulties in the processes of public interest litigation. But after a little while, before that we will have to discuss how the processes start. In case of legal proceedings start in a public interest litigation. So this is the concept of public interest litigation. It is a concept, I repeat again, it is a concept of recent origin, and it has occupied a very important position in the legal regime of present day world, and particularly in the field of public law in different legal systems. So this is the concept of public interest litigation, and I am sure you have understood the concept of public interest litigation, what I have taught. And if you have any doubt, any query, any question to be known or to be asked, you can definitely contact me in the WhatsApp group so that we can clarify our thoughts regarding public interest litigation or any other topic of the paper. I'll try my best to explain to you as far as possible. So far my knowledge goes. I have also limitations, but what I understand, I have taught you, I have clarified to you, and I hope you have understood something at least regarding public interest litigation. Thank you.